me to introduce Drew Kelsall. So Drew has a long history in the Bachelor of Arts at McGill, History and International Relations. He got out of that in 2011. Lived in Australia, did law at the Bond University there, then completed his Juris Doctor at Queen's University in 2015. He's completed the International Business Law program, Beta International Studies at, I'm not going to pronounce that, Kelsall in England. I'm looking at that going, oh, it's kind of like French and Celtic all jammed into one word. My apologies, Drew. He's also done matrimonial and family law, and then he joined MDK. And since then, he's working on corporate commercial matters such as incorporation, shareholder agreements, which he's going to be talking about. He advises clients on data protection and privacy related matters, which is very important, assisting companies, both startups and established entities, ensuring they are compliant with all legislation, both provincially and federally. He also assists corporations through large financings and other security transactions. That can't be too much fun, eh? Large money, large problems. Outside the office, he enjoys skiing during the winter and traveling and relaxing in his family's cottage in Muskoka. He's an accomplished tenor saxophonist. Saxophonist. Drew, I'm going to let you say that. It's a tongue twister for me today. And he has interest in science fiction and video games. Over to you, Drew.
Thanks, Bernie. Great introduction. Yeah, as Bernie said, I do play the tenor saxophone. I have done for many years. And in case you're wondering, Bernie, the castle is Herstmonceaux. Herstmonceaux. They have Queen's actually owns that castle in England, and they run a sort of program out of there for undergrad students and law students to sort of get some credits while getting some experience on sort of continental Europe and United Kingdom, going to sort of World Health Organization, World Trade Organization, The Hague, that sort of thing. Very interesting program. So I guess I'll start sharing my screen. Make sure that I don't pull up anything confidential. There we go. All right. So today's talk that I was asked to discuss was some of the legal considerations about whether or not to incorporate your business. So just for those of you who like an agenda on these sort of talks, I'm just going to walk you through sort of where we're going to go in the next sort of 25 minutes to half an hour. We're going to start looking at the various business structures that you do have to choose from outside of corporations. There are a variety of others that make sense depending on your stage of business and what your risks are. Then we're going to go into one of the most important documents, particularly if you have, say, more than one founder or are thinking of issuing shares to maybe some investors or some family members. Is a shareholders agreement. It's very important to have. Then we're going to look into a bit more detail in the shareholders agreement and go through some of the buy-sell provisions, which make up a substantial portion of the shareholders agreement, and sort of go through some of those situations where those buy-sell provisions would arise and what they actually mean. Finally, I'm going to touch on the corporate minute book and the importance of having the minute book sort of up to date and actually making sure that you stay up with all of your corporate responsibilities. So without further ado, I'll jump into our business structures slide. So there are three main areas that you want to consider when determining what structure you want to form. Be it a corporation, a sole proprietorship, a joint venture, partnership, corporation, whatever. And those three areas are flexibility, liability, and the creation of a separate existence. And I'll get to that third point in a bit because it may seem a bit confusing off the top. So starting with the more flexible business structure that if you want to go into business, that is probably the easiest way of really getting out there, is a sole proprietorship. As I mentioned, it's the most flexible. All you really need to do is register your business name in the province where you're doing business. hang a shingle outside your door or a sign, and you're essentially good to go. It's not quite as simple as that, but it is very flexible. There's a lot of options open to you, and it's generally the easiest, cheapest way to go when you're just starting out. Many fledgling businesses actually do start out as sole proprietorships and then may incorporate later on down the road when say their risk of liability increases, or if they want to take on investments, or if they want to protect their intellectual property. Some sole proprietorships never actually do end up incorporating because the nature of their business just doesn't give rise to that risk of getting sued and having to pay damages. For example, if your business is maybe giving dogs haircuts, for example, you may not run into significant legal liability just because you botched the job, maybe. Whereas a doctor might have other considerations, or a pharmacist, for example. One of the biggest risks with a sole proprietorship, as you can see, this little guy is sort of sitting between flexibility and liability, is that you actually have no protection against legal liability. Your own personal assets and you personally can be sued for the conduct of your employees or the business. If something goes wrong, breach of contract, all like your house, your bank account, your car, all of that stuff can be up for grabs by the courts. So when you're considering whether you want to incorporate, you should consider sort of the worst case scenarios, and us lawyers are really good at figuring those out, and determine, if I get sued and it's the really worst case scenario, how much am I at risk of losing? Could I be destitute and left homeless because my only asset is my house and I just got sued for $2 million because I did something wrong or I breached a contract? That's a really important thing to consider when determining whether to go with sole proprietorships or a corporation. The second sort of business structure that also lends itself to flexibility would be a partnership. A partnership is formed when two or more people are carrying on a business in common with a view to a profit. That's actually the legal definition, and it's important to remember that the term partnership is bandied about a lot in the corporate world. A lot of it is generally colloquially referring to business partners. In a legal context, a partnership is a very specific form of business structure, and it's formed under the Partnerships Act. The Partnerships Act governs partnerships and sort of tells you what you can and can't have in your partnership agreement. Now, the Partnerships Act is extremely short comparatively for legislation. And so it actually gives you a wide range of flexibility when it comes to what you can put in your partnership agreement. As with a sole proprietorship, however, there is still that risk of legal liability. In a partnership, the assets and liabilities of that partnership are shared between all of the partners. Now that there can be sort of differing levels of stakeholders. For example, one partner could contribute 25%, the other contributes 75%, and therefore the liability would be apportioned in accordance with that 25% to 75 split. However, the issue is still that your personal assets could be up for grabs in the event that the partnership gets sued, or a partner gets sued, rather. And that actually happens even if you had nothing to do with what that partner did. And that sort of depends on your partnership agreement, but in some circumstances, if one partner in a partnership gets sued, then the rest of them could be liable and their assets could be up for grabs. So the partnership agreement is really important to make sure you hammer out all of those details to make sure you cover all of your risks. The next form of business structure is probably the one you're more interested in, is the corporation. The corporation is far more rigid.
Frozen.
I think that Drew is frozen.
Yeah. Hopefully he comes back.
You've decided, okay, my risk is high enough. Oh, sorry, I just got a notification that my internet is unstable. So if I freeze, I apologize. Hopefully I'm back. So I'll just back up a little bit just in case you missed something. In Canada, we have provincial and federal legislation. You can either incorporate your business federally or provincially, and that's the decision you want to make right at the beginning. And it will really depend on where you're doing business. If you have a British Columbia company and you're never going to really do business outside of BC, it wouldn't make sense to incorporate federally. Whereas if you potentially plan on doing business across Canada, you'd want to incorporate federally, because one of the advantages to incorporating federally, aside from the fact that it is actually cheaper than incorporating in Ontario, is that you actually get that protection over your business name across Canada. And all you need to do when you're going into another province is register your business, and you'll be good to go. Incorporating provincially, on the other hand, only protects your business name in that province. And someone else could start a similar business in, for example, a neighboring province with the same name. And unless you had already registered your trademark and protected your IP in that sense, they could continue on with that name because you don't have that federal protection. In contrast to the Partnerships Act, one of the reasons that the corporation business structure is far more rigid and doesn't allow for that flexibility is that the Ontario Business Corporations Act and the CBCA, the Canadian version, are very long. They're very long, they're very complex, and they're very detailed. And so there are a lot of requirements that must be met when you're actually going through the process of incorporating and making sure that the structure is right and all the documents are in place. The main benefit to it, to incorporating, maybe you're going from a sole prop right to an incorporation, or just going straight to the incorporating stage, is that when you incorporate, you actually create a separate legal entity. The corporation is considered a legal person. Not quite like on the individual level, but it's considered its own entity that can be sued and can sue. As a result, unless as a director or shareholder, you've personally guaranteed a loan, for example, to a bank, or you've given a personal guarantee, you as the owner of the corporation are not subject to personal liability. So for example, your own personal assets, your house, your bank account, those aren't up for grabs with a corporation. So if a corporation has $50,000 worth of assets and it gets sued for $2 million, the $50,000 goes towards that award, and that's it, because they can't really what's called pierce that corporate veil to go after the shareholders or the owners directly, except in very certain circumstances, which is a sort of a topic in and of itself, and so I probably won't touch on that today. Another advantage to incorporating is that they're meant to continue regardless of any changes of ownership. The corporation stays in existence regardless of whether a new owner comes in or the owner dies. It continues on, which is it's something that investors like to see, because it means that if something happens to that owner, their investment's protected, the business can keep on going, and they don't need to worry about having to deal with an estate and estate tax and things like that. The final advantage of a corporation that I'd mentioned is that if you're building IP, intellectual property, with someone else, such as a co-founder or family members or a friend, if something happens to that relationship, so you're working together, you've created this great app, you're ready to launch, and then the relationship sours and you part ways, having that corporation own the intellectual property that you create is a great way of sort of protecting it and making sure that that split of the relationship doesn't affect that IP and the ability for whoever keeps the business to continue on and actually use the intellectual property. Otherwise, you may run into a situation down the road where you are trying to sell your company and you're asked, well, do you own the IP? Does the company own the IP? And you have to say, well, actually, no. My old business partner who isn't speaking to me actually owns half of this. So now you need to go back and try and track him down and get him to sign an IP assignment agreement. And that can be very difficult. The final business structure that I'm going to touch on briefly, because they're a bit less common and they're a bit more complicated, are joint ventures. Joint ventures are sort of similar to partnerships in that it's sort of two entities coming together to work together. The key with a joint venture is typically that different rights and responsibilities are clearly set out in the agreement that creates the joint venture. For example, it's usually two entities that sort of bring differing levels of experience or expertise to the table. Maybe a marketing person and a developer can create a joint venture because they each have their own roles set out and the liability can be apportioned as such. So one of the, for the rest of this, I will be focusing on corporations. I did want to just touch on those business structures quickly because it is important to know that there are other options out there and corporation may not actually make the most sense depending on what stage you're at. Risk is a big thing. Sometimes it doesn't make sense from an accounting perspective or a tax perspective. And I would encourage you to consult your accountant and legal professional to determine when is the best time to incorporate, because there will be some tax considerations and things like that. So moving on into the corporation side of things, one of the sort of perhaps the most important document that you can have if you have more than one founder or you're issuing shares and you're going to have more than one shareholder is the Shareholders Agreement. The Shareholders Agreement is the main governing document of your corporation. It sets out the rights and responsibilities of the shareholders, directors, and governs who has decision-making authority over certain aspects of the corporation. So if you think about a corporation, there's really three levels to consider. At the very top, you have the shareholders. They're the actual owners of the corporation. So they each have their shares, and that's a percentage ownership. And usually those shares carry some specific rights. Maybe their voting rights, maybe their rights to dividends, maybe their rights to get the assets on liquidation. So like, sorry, my monitor just disappeared for a second. My apologies. Oh, there we go, it's back on. So yeah, it really you have those shareholders at the very top, and then the shareholders elect or appoint, or certain shareholders have the power to elect or appoint directors to the board of directors. So under the shareholders, you have that middle level of the board of directors. The board of directors generally oversees the broader picture management of the corporation, sort of the budget, the financial aspects, less of the day-to-day stuff. Underneath the directors, you have the officers. Officers and directors can be the same people. And officers would be like your CEO, your chief technology officer, your chief financial officer. You can really make up however many names you want for these officers, but they manage more of the day-to-day aspects of the business. Now, an important thing to remember about shareholders agreements is they are not all the same. You can have an agreement that has different sets of rights for different classes of shareholders, such as more power for the majority shareholders, these two big guys here, and then less for minority shareholders, this group of smaller individuals. Typically, that carries with it a sort of difference in who can vote on certain matters. Majority shareholders typically retain voting rights, and minority shareholders, for example, family members who you don't really want in the day-to-day operations of the business, would not have voting shares. Shareholders agreements also typically govern what happens when investors come in, what happens when you want to sell the business, and it really sets out who gets to make those decisions. Sometimes it's the shareholders, and you have to get all of the, or a certain percentage of the shareholders to approve of a decision. And other times the directors can go ahead and make that decision at a board of directors meeting, and then it's good to go. So there's our investor. So shareholders agreement contents, there's a lot that goes into these shareholders agreements, and there are really three main sections. The first is governance, the second is day-to-day operations, and the third is what we're going to get to next, which would be the buy-sell provisions, is the terms on which you can sell or transfer your shares. So under the governance aspect, there are two types of shareholders agreements. There are the unanimous shareholders agreements, which is actually something that you enter into under a specific section of the Canadian Business Corporations Act. It's a specific type of shareholders agreement. The unanimous shareholders agreement is among all of the corporation's shareholders, and it actually restricts the powers of the directors to manage or supervise the management of the business and affairs of the corporation. So it really sort of puts a handcuff on the board of directors and say, like, you can't make any of these decisions, these specific decisions, without getting the shareholders' approval. So it's a way of the shareholders maintaining that control over what actually happens with that corporation. The governance will also set out who has what rights, sort of shareholders versus security holders. Security holders, there's a difference between shareholders and security holders. Shareholders would typically own your standard common shares that they've purchased in return for cash or some other investment like sweat equity or something like that. They can typically be sold subject to certain conditions, and the owner of the shares is typically entitled to benefit from future sales of the corporation. So if the corporation is sold, the shares are sold and they get their money. Security holders, on the other hand, typically hold some other type of security in the company, some other type of convertible debt. Typically, that's sort of is the form of a preferred share that can be converted into cash, or another type of debt, such as a promissory note. So it's sort of saying, I promise, the corporation promises to pay investor $175,000 in return for a promissory note, and the investor has the promissory note, and when it's up, they can take it to the corporation and convert that debt into cash. And the shareholders agreement would set out those sort of rights and responsibilities of the shareholders and security holders. It would also touch on, as I mentioned, majority versus minority shareholders' rights. If you have a minority shareholder group, then you might want them to sign a voting trust, which essentially puts if they have voting rights, you could put all of those voting rights into one of the directors, and so, or into the founder, such that that decision-making power always stays in the founder, even though those shares carry voting rights. You can also, you put in provisions to the shareholders agreement about who's nominating directors, what certain decisions have to have shareholder approval, including amending or terminating the agreement. Typically, I believe the corporate sort of threshold is 66 2/3%. So if you get to that level, then you're approved and you can terminate or amend the agreement or make specific decisions. For the day-to-day operations, the shareholders agreement really governs sort of the appointment of officers. As I mentioned, that's the chief executive officer, your CFO, your CTO. The officers would be responsible for ensuring regulatory compliance, getting the financial statements prepared, preparing the budget, etc. The shareholders agreement would also contain provisions regarding the use of profits, whether the company reinvests them or declares dividends and pays shareholders, whether the company can take on loans, if so, how much, and whether they can take them from the shareholders or investors. Pretty much just how the business runs are these clauses in the shareholders agreement. The final thing I wanted to mention about the day-to-day operations would be the key person insurance. You'll see that down there on the slide. An important thing to remember about incorporating your business is, while I did mention that it is a separate legal entity and your personal liability isn't as much at risk, there are certain circumstances where directors of a corporation can be held personally liable for certain acts of the company. For example, if the company has employees, the company has an obligation to remit income tax, CPP, EI, all that stuff to the Canadian Revenue Agency, because we all know that the CRA at the end of the day gets what they want to get. If your company has fallen behind on those payments, remitting the income tax, remitting the employment insurance, the directors of the company can be held personally liable for that failure. And at that point, their personal assets can be up for grabs. And there are a number of pieces of legislation, pieces of law in Canada that actually provide for different scenarios where the directors can have personal liability. For example, certain environmental actions. If you pollute, the directors can be held responsible. And sometimes you'll have someone who you want to be on the board of directors and they won't want to because they don't want to accept that personal liability. Key person insurance is one of those ways that you can entice them into joining the board, because you say, well, join our board, you will potentially be personally liable for this stuff, but we have key person insurance, usually called directors and officers insurance, that can sort of cover you if something happens. Like your personal assets won't be up for grabs. We can use the insurance policy and we're all good. So that is it's a good way of enticing people onto the board to bring certain expertise or skill sets. And it's important to also consult your insurance broker, because there are a number of different insurance policies you can get, both for directors and officers, errors and omissions, and also for things like cybersecurity. So moving on to probably one of the biggest, sort of more complex aspects of the shareholders agreement would be the buy-sell provisions. Usually the ability of a shareholder to purchase or sell their shares is restricted by these provisions. So I'm going to go through each one of these: the preemptive rights, right of first refusal, piggyback, drag along, and shotgun clause, and just briefly explain sort of what they are. So the preemptive rights is probably the easiest one. So say an investor comes along and offers to purchase shares of your company for $100,000. The preemptive right, it gives existing shareholders the right to participate in that round at the same price. So an investor approaches you, $100,000, I want shares. You then have to go to all the rest of the shareholders and say, hey, we've got this deal for $100,000. Do you want to participate and buy shares on those same terms? Another aspect of this is if someone is trying to purchase your shares, they would have the ability to purchase them first. So that would be the right, and that's getting into the right of first refusal. So if we're not dealing with really investors coming in, now we're dealing with someone who's offering to purchase your shares. So the right of first refusal, someone comes along and offers to purchase your shares. So you're a shareholder selling to a non-shareholder. The current shareholders would have the right to purchase your shares. So you would turn to the shareholders and say, hey, I've got this deal. Someone wants to buy my shares, but you have a right of first refusal. So do you want to buy them instead? And they can essentially tell the third party to take a hike and buy that shareholder's shares. The piggyback clause it's triggered sometimes when nobody exercises that right of first refusal. So someone's offered to purchase your shares, nobody wants to purchase them, and so you're free to go and sell your shares to the third party. If there's a piggyback clause, other shareholders can piggyback on that sale. They can jump on and sell their shares to the third party as well. And in this situation, the third party purchaser would have to determine sort of whether they want to come up with more money and purchase all the shares from all of those shareholders, or split their initial payment through all of those shareholders. So it's a way to sort of jump on another person's good fortune and say, actually, you know what, you're selling 100,000 shares. I want to sell 100,000 shares too. And now the investor needs to think, okay, well, do I buy 50 from each, or do I buy 200,000 shares and double the price? For a drag-along clause, if a certain percentage of shareholders want to sell shares to a non-shareholder, to a third party, so say 65% or 75% of the shareholders want to sell their shares, a drag-along clause enables those shareholders to drag the rest of the shareholders and force them to sell their shares as well. So you would go to them and say, well, we've got 75% who want to sell their shares. We're triggering the drag-along clause, and the rest of you 25% who don't want to come have to. You have to sell your shares regardless. So that's one way of sort of making sure that a sale does actually go through and you close the transaction, because it sort of addresses those maybe few shareholders who are a bit more hesitant. The final clause I wanted to go through is the shotgun clause. It sounds the most fun, but it's really just, it's a blunt instrument that is used when there are two shareholders deadlocked in a dispute. The shotgun clause enables one shareholder to make a compulsory offer to the other shareholder to sell their shares or buy the other's shares. So for example, I would approach the shareholder that I'm having an issue with and say, hey, I want you out. I'm buying your shares for $500,000. So I've triggered the shotgun clause. The other party now has the option to say, okay, buy out my shares and I'm gone. Or they can turn around and say, well, actually, no, I'm going to buy your shares for $500,000 and I would have to sell them. Like mandatory, I have to sell them. So that's the shotgun clause. And it's tricky because you really need to figure out, you got to know your other party and figure out whether you can get a price high enough that they can't match it. So then you're assured of buying their shares. If you say I'll buy them for 500 and he says, yeah, sure, I've got that in the bank. Actually, I'm buying your shares. Then you have to sell them. So it's a very blunt instrument, and it's really only used in deadlock decisions, or deadlock disputes. But it's a very efficient, good way of resolving those disputes because it's quite blunt and it's just cut and dry. Like, I want to buy your shares. Too bad, I'm buying yours. Is really the way to do it. So those are the main buy-sell provisions that are found in shareholders agreements. There are a number of other ones that are also included. For example, what happens on the death or disability of a shareholder. And you can also include provisions of what happens in the event of a divorce. As Bernie mentioned, or Margaret Ann mentioned, I did used to practice family law, and this does happen. And you do want to have those buy-sell provisions in your shareholders agreement, so your company doesn't end up half-owned by a disgruntled ex-spouse who's going to do everything they can to block the business. So the final thing that I wanted to touch on today was the corporate minute book. We actually see a lot of clients come in to our office who have incorporated online, and frequently those online incorporations, while they seem easy, they don't actually give you everything you need to have a legally compliant corporation and to have it in compliance with the Canadian Business Corporations Act. And some of the, like, you usually get an articles of incorporation and your certificate of incorporation. You also need share terms, annual resolutions, organizing resolutions, directors resolutions, bylaws, and a number of other matters when you first incorporate. So I would encourage you to contact a legal professional when you're considering incorporating to make sure that you sort of do it right the first time, because sometimes going back, sometimes over 3, 4, 5 years and putting together all the resolutions that you need to get the minute book up to date can be a lot more expensive than just sort of doing it right the first time. So the minute book is essentially the history of your corporation. It contains a record of all the transactions that have taken place, who are the shareholders, who are the directors, who are the officers, who's resigned, when they were appointed, a record of any financing or share issuance, share transfers. Pretty much everything the corporation does is in that minute book. Including all of the resolutions of the board of directors or the shareholders approving those decisions. So it's actually really important to keep the minute book up to date. And it's important to have your minute book, not just because it's the law and you have to have one, but also because it is that paper trail that if you run into a dispute in the future with a shareholder who says, you know what, I never voted for that at that meeting, I never agreed to that, and you can pull out your annual resolutions or the scrutineer's report from your annual general meeting of the shareholders, and you can point to that vote and say, actually, no, you agreed to this back 6 months ago, and so it's in paper, it's in our minute book. You can't go back and say you didn't do it. Another reason why you'd want to have an up-to-date minute book and make sure that it's kept up to date is for future financings or future sales or acquisitions of the business. Typically, when an investor comes along and wants to invest in your business and purchase shares, they will want to look at your minute book, and they'll usually go through it with a very fine-tooth comb, because they want to know who owns the shares. They want to know who the directors are. They want to know whether the corporation has been keeping up with its responsibilities. And if you give them a minute book that's sort of this thin and has nothing in it, they're for 10 years of corporate work, the investor is going to look at that and think, if they can't even keep their corporate minute book together, then how am I going to be able to do business with these guys? What am I actually buying by investing all this money? And that will actually happen with sales and acquisitions of the business as well. The broker might want to look at the minute book, and they'll want to see sort of what debts you've taken on, have the shareholders personally guaranteed any loans, that sort of thing. So the minute book is very important, and it's something that is often overlooked, that once you've incorporated, you think you're good to go. You're not. There are a lot of annual things that you need to do, like financial accounting, preparing your financial statements, waiving the mandatory audit provisions in the Canadian corporate law, things like that. And so it's very, very good to keep those up to date. And many law firms actually do have minute book storage services where you could keep your minute book and give you reminders to update it, draft the resolution, stuff like that. So probably the two biggest things for your corporation would be the shareholders agreement and minute book. So I think that sort of reaches the end of what I wanted to chat about today. If there are any questions, I'm happy to answer them, just with the one caveat that I am actually prohibited by the Law Society from giving legal advice in these sorts of settings. So maybe for any specific questions that are getting into very individualized circumstances, I would encourage you to reach out to either our firm or your own legal professionals for further advice. Thanks.